Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about breath testing and your charter rights. Cases that should have gone to the Supreme Court of Canada, but didn't. Several years ago, the Supreme Court of Canada determined that if police do not conduct an observation period, which is part of a proper breath testing procedure in impaired driving investigations, that it was essentially irrelevant so long as there was no actual evidence of burping, regurgitation, vomiting, or anything taken by mouth that could impact the validity of the samples. As a result, people were unable to argue that because an officer didn't actually engage in the observation period or conducted a flawed observation period, their samples should be considered to be unreliable, even though the police training was to take the samples after doing that and that the observation was essential to a proper breath test. Mr. McManus brought a charter challenge to his breath tests, essentially arguing that the failure of the officer to conduct an observation period might not have affected the scientific validity of the tests, but it did violate his Section 8 charter rights. Essentially, he argued that by conducting the tests improperly, the police had engaged in an unreasonable search in his body for breath samples. And the court ultimately dismissed his charter challenge, finding that it was not unreasonable to take samples in circumstances even where the police have been trained that the results would be not reliable. The Supreme Court of Canada denied leave to appeal and refused to hear the case. And obviously this case raises important issues. If police are trained to conduct a search a certain way, and if they're trained that there are legitimate scientific reasons for that search, and the searches are done by operation of a law without a warrant, should it not then be the case that strict compliance with the training and the scientific protocols surrounding the testing is done in order for the searches to fall within the authorized by law itself is reasonable, and the manner in which the search is conducted is reasonable analysis that's done to determine whether or not there's a Section 8 unreasonable search and seizure breach? This case is confusing in the sense that it essentially seems to set up a standard whereby police can knowingly conduct searches improperly, particularly where the results of those searches can then be used as the determinative evidence in a criminal prosecution and as determinative evidence for administrative consequences, and yet suffer no consequences to the admissibility of that evidence as a result of knowingly doing it improperly. This, to me, seems to be wrong, and the Supreme Court of Canada ought to have corrected this. It essentially gives the police carte blanche to go around violating charter rights in the context of searches, and then just say, well, you know, there's a law that says that I can do it, so I did it, I just did it wrong, but it doesn't matter. This cannot be the state of Section 8 litigation in Canada. Unfortunately, the Supreme Court of Canada, I think, missed the opportunity to see the significant watering down of Section 8 rights that comes from judgments like this. And hopefully there's another chance that the Supreme Court of Canada gives for the opportunity to review the taking of breath samples in circumstances where police are trained they would not be reliable, regardless of whether there's actual evidence that they weren't reliable in those circumstances. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada But Didn't. I'm Kyla Lee at Acumen Law. Thank you to Reasonable Creative for putting together these videos. Please like, subscribe, and share with your friends.